Our organisation's the Regional Law Centre, and we work with membership organisations who are community advice centres. And really what I've heard from the speakers is communication, and it's again our experience is key, making sure that you can work with those people and get the cases and the individuals aware of their rights. I think the issue is particularly about making sure litigation in the area of social and economic rights is seen as a legitimate remedy, and I think that's a big message that we still have to get through both in the judiciary and in the community.
While public interest law is not exclusively about going to court, litigation is important. Here is Julian Burnside on his own experiences and on using the courts in Australia.
I want to make it my purpose today to fire up at least some of you to the idea of engaging in public interest law in general, and perhaps public interest litigation in particular, because that happens to be my interest. Now, I am a litigator. In fact, I'm a commercial litigator, and having quenched my passions in tax appeals, takeovers and trade practices, it came as something of a surprise to find myself in court acting pro bono for the asylum seekers who'd been rescued by the Tampa in August 2001. I knew nothing about refugee law or policy in Australia, and although I had been involved in public interest litigation in other fields before, this was my first contact with anything to do with refugees. And my reason for doing the case was the obvious fact that to hold 430 people who'd just been rescued from drowning in the course of fleeing the Taliban, to leave those people on the deck of a ship in the tropics and refuse them permission to come ashore for medical help was just plain wrong, morally indefensible. And so we came up with a device which we hoped would provide a legal remedy to what was a terrible humanitarian problem. Some people don't like to think that litigation can be used as a legitimate instrument of social policy. I would take issue with that. It seems to me that if the law offers a right which can be invoked in new ways, then that's precisely what the courts are for. And by the same token, if an injustice is embedded in the law, then litigation may expose the injustice and may draw attention to it sufficiently to cause the parliamentarians to alter the law so as to remove the injustice. But nothing is surer than this. If you don't challenge laws that are inherently unjust, you will never be able to resolve the injustice which they create. The practice of law, as many of you know, offers many rewards. Only one of them is money, and I would say it is the least of them. One of the great rewards of practicing law is the ability, in every case you do, to make some sort of difference. Some cases will only make a difference to the individual litigants, but it's essential that those cases be run properly and competently in accordance with the law, or else the legal system itself makes no sense. That's why properly funded legal aid is so profoundly important. If the law is not capable of being deployed properly in every case, then the whole legal system fails and justice is diminished. But there are times when the law betrays justice itself. And Arundhati Roy, who may be familiar to you as the author of The God of Small Things, is a well-known political activist in India. She wrote an essay once in which she said, "A thing once seen cannot be unseen. And when you have seen a great moral wrong, to remain silent is as much a political act as to speak against it." And that's the challenge which faces lawyers, because if a lawyer's vocation is justice, then we can't be blind to injustice. And when a lawyer sees a source of injustice, whatever it is, you have a stark choice. You can go along with it, tolerate it, and put it out of your conscience. Or you can take a stand against it. And by taking a stand against it, you will help achieve greater justice in the community. And you will, in that extent, change the world and for the better.
He also speaks about another potential source of major injustice, as does Professor Gerard Quinn, conference rapporteur.
The second major source of injustice, potentially in any legal system, is the existence of laws which are in themselves bad laws. They may be valid, but they may operate harshly And of course, this is a problem in a majoritarian system. Now, redressing either kind of injustice of these sorts does require a combination of things. One is properly funded legal aid, and the other is a healthy tradition of public interest law, including, of course, the willingness of practitioners to act for no charge in order to redress injustices. And it's interesting to think pro bono publico means for the good of the public. And it's interesting and significant, I think, that pro bono legal work is synonymous with free legal work, because, of course, work done in the interest of the public is usually in the interest of the disadvantaged, the oppressed, the unpopular minorities, because the rich don't generally need that sort of support. The rich do much better in the system which is, to a large extent, designed by them and operated for them.
Now, we can also see that there is, or there ought to be, a very, very clear connection between law and justice. After all, the whole point of law is to regulate behaviour justly and not just efficiently. And I think this is really something that Robert Garcia was very usefully pointing his finger to. And without that connectedness to justice, law simply loses legitimacy as well as effectiveness.
Gerard Quinn spoke about law in the context of the marketplace for legal services and those who fall through the gaps, as does Michael Farrell.
Rather, I think we're here because that marketplace only tends to respond to listen to those with voice, with power and with resources. The marketplace has gaps, in other words. There are certain issues that do not get a full hearing because there's no natural constituency to back them up. And there are certain groups whose just claims never get full ventilation because, despite their numbers, they're simply not listened to with respect in the political process. If no one speaks for the public interest with respect to these issues or these groups, then nothing happens, essentially.
I've focused in this paper largely on the continuing deprivation, inequality and social exclusion in our increasingly wealthy society, and on the role of public interest law in helping to end that deprivation and exclusion. But lest that seem to be too negative an approach, we should also stress that the combination of fundamental human rights provisions in the Constitution, the incorporation of the European Convention, the international conventions that we have signed up to, provide the basis for building a society firmly founded upon human rights and where all public policy decisions should be proofed beforehand for compliance with our human rights commitments. And for the first time, too, our economic prosperity leaves government with no excuse for failure to comply with those human rights commitments. And we as lawyers, and as members of the NGOs and everybody else interested in this area, have a golden opportunity now to contribute to the building of an inclusive, rights-based society in Ireland, and we have the means to do it for perhaps the first time.